Whether you're buying or selling a property, there are a few conditions you need to consider. So let's have a quick chat about that. There are 3 really important conditions you need to put in a contract as a purchaser. So the first condition you need to consider putting in a contract is a finance condition. So the reason for the finance condition is to allow you time to organise finance with a bank or financier. Usually these are anywhere between 5 to 15 days. The second condition is a builder's report that enables you to get a builder in to look at the property, ensure there's no defects that will be detrimental to you. The third condition is the LIM report condition. A LIM report is a document that is accessed from the council that outlines information pertaining specifically to the property that you're purchasing, including information such as zoning issues and whether there's been consents applied for and given. Another condition you can consider is solicitor's approval of both the agreement and the title. If you haven't had an option to see a solicitor before signing, then that's a really good condition to put in there, ensure there's nothing detrimental in that agreement. Another condition you can consider when purchasing is solicitor's approval of the title. The title is a document that's held with the land registry, stating who the registered proprietors of the property are and what interests are listed on that title, such as mortgages, sewage easements, right-of-ways. The title has a second page which shows the outline of the property. The lawyer's job would be to check those out and ensure that all services are to the property, as well as looking at the interests to see if there's anything detrimental. As a seller, there are 2 conditions that you need to consider. The first condition would be a cash out clause, which means if you get a contract that has conditions in it that take time to be satisfied and another purchaser comes along with an offer that is the same or better, you can then invoke the cash out clause. As a vendor, you could put in a condition of due completion, which means if you sell your house, that the purchase contract is not actually unconditional until you sell. The main reason you put a due completion clause in is that if you have a bogus buyer, and this does happen but very rarely, that you are saying that you must satisfy your sale contract before you can purchase. No, you cannot rely on a verbal agreement. Under New Zealand law, all land purchases must be in writing. If you suspect the property has been used for drug use, it's a good idea to put in a condition requiring drug testing, especially methamphetamine. Don't sign anything until you've seen your solicitor. It's better to spend a few dollars with us first, ensuring that the agreement suits your purposes, than find yourself stuck in a contract that you can't get out of. As no 2 sale and purchases are the same, it's really important that you come and have a chat with us about what conditions are necessary for your circumstances. We'd love to help.